to share with you today something that I call the authority timeline. It's a timeline that I've devised to explain the engagement of the criminal justice process against you as an involuntary participant. And the best way to explain this is by way of example, using myself. Let's say I get my sexual kicks by touching people on the knee. I have my cameraman here today. Joel, can I touch him on the knee? He's shaking vigorously no. I touch him on the knee. Arguably, that's a sexual assault. Now I have to worry, am I going to be charged? Am I going to be in the sex offender registry? How does the process get manifested against me? Well, the first decision maker is Joel. He is the complainant. And at this stage of the proceedings, Joel has all the power over me. He makes a decision to complain to the police or not. Joel can walk in the door, or he can complain to the police. And let's assume in this example he does call the police. And the police show up and Joel tells his story and they do an investigation. But once the police are here and that's done, Joel loses all control. The police now have control. They have to decide if they believe an offense has been committed. And if they do believe, then they have to make a decision, right? They can arrest me, they can charge me, later charge in court, and then they can hold me for a bail hearing. These are all police decisions. Not Joel's decision, not the Crown Attorney's decision, but police decisions based on whether or not there's a belief in an offense and they want to proceed with an arrest, charge, and holding me for a bail hearing or releasing me from the police station. Once the police charge me, let's say in this example the police do charge me, I get to court. Well, once I'm in court and I'm charged, the police lose control in terms of the engagement of the process against me as an accused person. Then it's the Crown Attorney that we're dealing with. The Crown is a lawyer just like me who prosecutes all criminal charges in Ontario on behalf of Her Majesty the Queen. In all cases, the Crown is making a decision to proceed or not proceed. So there is a charge screening process in place in this province where the Crown will review a case at the very beginning to see if they're going to proceed with the charge. And that's an evaluation that is in fact made throughout the case as information is revealed, documents are reviewed, and all of that about the case. Once the Crown looks at it and says, yes, Craig Penney, we finally got it, we're going to prosecute this to the fullest extent of the law, then they lose control and it shifts to the judge. Or if you're having a jury trial, ultimately the jury will decide your fate. And the judge decides whether you're guilty or not guilty, and if you're guilty, then the judge will decide what your sentence should be. I have cases in all four categories. Sometimes I'm dealing with a complainant where I'm trying to convince the complainant directly that it's a misunderstanding or it's a civil issue. Sometimes I'm dealing with the police where I want to supply them with information or I want to dialogue with the police to convince them that there is really no reasonable belief in an offense and there's no need to charge my client. Most often I'm dealing with the Crown in the pretrial process, collecting disclosure, having a dialogue with the Crown, trying to convince the Crown not to proceed. And clients always ask me, how can we convince the Crown not to proceed? Well, essentially there's two ways. First, we can convince the Crown there's no reasonable prospect of conviction. No reasonable prospect of conviction. And this is a legal test. It's a legal test. It's applied to the anticipated evidence as we see it unfolding. And essentially what I'm trying to convince the Crown here is that you have no case. The second way is that it's not in the public interest to proceed. You may have heard the term restorative justice. Well, there are many minor cases, a lot of domestic cases, where it's not in the public interest. It's better for the community and for the accused and for everybody involved, for example, for the accused to get counseling or attend a PARS program dealing with domestic violence, and that the person not be prosecuted in a formal way. We also have many cases that for dealing with mental health issues where it's not in the public interest and it's much better that the accused person get mental health assistance. Okay? So this is the authority timeline. Keep it all in line. It's not meant to be advice. If you need advice, then speak to your lawyer or call me and seek a second opinion.